A police officer leans slightly toward your car window. The flashing lights behind you paint the road in red and blue reflections. The moment feels ordinary, something that happens thousands of times every single day across the country. But what happens in the next few seconds can quietly shape the rest of your legal future. Because sometimes a person says something small, just a few casual words spoken without thinking, often out of nervousness or politeness, and those few words can later appear in a police report, in a courtroom transcript, or even in front of a jury. Not because they were intended to cause harm, but because the law treats certain statements very differently than people expect. So let me ask you something before we go any further. If a police officer asked you a simple question and you responded with just a few casual words, do you think those words could later be used to damage your legal case? Most people would probably say no. Most people assume that only dramatic confessions or obvious admissions matter in court. But legal history tells a very different story. Across thousands of real cases, lawyers and investigators have repeatedly seen situations where just a short phrase, sometimes only a handful of words, ended up changing how a judge, prosecutor, or jury interpreted an entire situation. And one of the most surprising examples of this involves 5 words that people often say without even realizing the legal meaning behind them. I didn't mean to do it. At first glance, those words sound harmless. They sound human. In fact, they sound like the kind of thing a person might say when they are simply trying to explain themselves. But in certain legal contexts, those 5 words can create a serious problem. To understand why, we need to step back for a moment and look at something fundamental about how the legal system works. In many legal cases, especially criminal cases, prosecutors must prove 2 major elements. First, they must show that a specific act occurred. Second, they must show a particular mental state connected to that act. In legal terminology, these 2 concepts are often referred to as actus reus and mens rea. Those Latin terms simply mean the physical act and the mental intent behind the act. Now here's where things become interesting. Sometimes the most difficult part of a case is not proving that something happened. The physical event may already be obvious. The difficult part is proving what someone was thinking when it happened. Did the person intend to cause harm? Were they reckless? Was it an accident? Was it negligence? These questions often sit at the center of legal disputes. And because intent is internal, something that exists in a person's mind, investigators often rely on statements people make to help interpret that intent. That is why casual language can sometimes carry enormous legal weight. When someone says the words, "I didn't mean to do it," they may believe they are explaining that the situation was accidental. But depending on the circumstances, those same words can also be interpreted as acknowledging that the act itself occurred. In other words, the statement can unintentionally confirm a key part of the prosecutor's argument. This type of situation has appeared in many real legal cases. Imagine a scenario involving a traffic accident. 2 drivers collide at an intersection. No one planned for it to happen. Emotions are high. Adrenaline is flowing. One driver steps out of their car and says to the other driver, "I'm sorry, I didn't mean to hit you." From a human perspective, that sounds like basic decency. Many people instinctively apologize after an accident. But later, when insurance companies and attorneys begin reviewing the case, that statement may be interpreted as acknowledging responsibility, even though the driver may have only been expressing empathy. This is why some states in the United States have adopted what are known as apology laws. These laws recognize that people often apologize after accidents simply to express sympathy, not to admit legal fault. However, those protections vary by jurisdiction, and they do not always apply in every situation. This creates a complicated reality. The things people say during stressful moments can later appear in legal documents long after the moment itself has passed, and sometimes those statements carry meanings that the speaker never intended. Let me ask you another question. If you were in a stressful situation involving law enforcement, do you think your natural instinct would be to speak freely and explain yourself? For many people, the answer is yes. Humans are social creatures. When confronted with authority or confusion, we often try to talk our way through the situation. But experienced defense attorneys often warn clients about something important. Anything you say can potentially become part of the record. This is not just a phrase people hear in television dramas. It reflects a real legal principle. Statements made voluntarily can often be used as evidence if they are relevant to a case. And the interpretation of those statements may not always match what the speaker originally intended. That is why many legal experts emphasize the importance of understanding one's rights during interactions with law enforcement. One of the most well-known examples of this comes from the famous U.S. Supreme Court case Miranda v. Arizona in 1966. In that case, the court ruled that individuals in police custody must be informed of certain rights before interrogation. These include the right to remain silent and the right to have an attorney present during questioning. The decision established what many people now recognize as the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Those words are now deeply embedded in American legal culture, but their meaning is often misunderstood. The right to remain silent does not mean someone must refuse to speak in every situation. However, it does highlight an important legal reality. Statements can become evidence, and once a statement becomes evidence, it can be interpreted, debated, and analyzed in ways that the speaker may never have anticipated. This is why defense attorneys often advise people to be thoughtful about what they say in stressful situations. Not because silence implies guilt, but because speaking without fully understanding the legal implications can create unintended complications. Consider another example that has appeared in real legal cases. A person involved in a physical altercation tells police officers, "I didn't mean to hurt him." Again, the speaker may believe they are clarifying that the injury was accidental, but from a legal perspective, the statement can still be interpreted as acknowledging involvement in the event. That acknowledgement can influence how investigators frame the situation. It does not automatically determine guilt or innocence, but it becomes a piece of the puzzle, and once something enters the legal record, it often remains there. Court transcripts are remarkably detailed. Lawyers sometimes analyze statements word by word, exploring subtle differences in language. A phrase that seemed insignificant in the moment can later become the subject of extensive legal debate. This is why legal professionals often emphasize clarity and caution when discussing events connected to potential legal matters. It is not about hiding information or avoiding responsibility. It is about recognizing how language functions within the legal system. Now think about how people normally speak in everyday life. We use exaggerations, apologies, and informal expressions constantly. Someone bumps into a table and says, "I'm such an idiot." Someone arrives late and says, "That was totally my fault." Someone accidentally drops a glass and says, "I'm so sorry." These phrases are social habits. They help smooth interactions and express empathy. But legal environments operate differently from casual conversations. In legal settings, language is often examined with extraordinary precision. This difference between everyday communication and legal interpretation can surprise people who have never experienced the legal system directly. And that surprise is one reason why misunderstandings sometimes occur. Let me ask you something else. Have you ever apologized for something even when you weren't completely sure it was your fault? Many people have. Psychologists have studied this behavior extensively. Research suggests that apologizing can help reduce social tension and demonstrate empathy. In other words, people sometimes apologize simply to calm a situation, not to assign blame. But when those apologies appear in legal contexts, the interpretation can change. Attorneys may ask questions like, what exactly did the person mean by those words? Were they acknowledging responsibility? Were they expressing sympathy? Were they reacting emotionally? These questions become part of legal analysis, and the answers are not always obvious. This is why many legal educators emphasize the importance of understanding how the legal system interprets statements. It is not about memorizing complicated legal terminology. It is about recognizing that words spoken in stressful moments can carry unexpected weight. Some experienced attorneys even describe this as the difference between conversational language and evidentiary language. Conversational language is flexible and emotional. Evidentiary language is precise and subject to interpretation within legal frameworks. The same sentence can exist in both worlds, but its meaning may shift dramatically depending on the context. Throughout modern legal history, countless cases have illustrated this principle. Sometimes the key evidence in a case is not a dramatic confession or a complex forensic analysis. Sometimes it is a short statement recorded in a police report, a statement someone barely remembers making. But once that statement enters the legal process, it becomes part of the story that attorneys and juries examine. And stories matter deeply in courtrooms. Trials often revolve around competing narratives. One side presents a version of events, the other side presents a different version. Statements made by the people involved can influence how those narratives develop. This is why legal professionals often approach language with careful attention. Every word can matter, and that brings us back to the idea we started with. 5 simple words. I didn't mean to do it. Words that sound harmless. Words that sound human. Words that might be spoken during moments of confusion, fear, or regret. But words that can also create complicated interpretations once they enter the legal system. Understanding this does not mean people should live in constant fear of speaking. It simply means recognizing that certain environments, especially those involving legal investigations, operate under different rules than everyday conversation. And awareness of those rules can help people navigate stressful situations more thoughtfully. As we continue exploring this topic, we'll look at several real-world scenarios where statements played a crucial role in shaping legal outcomes. Some of these examples come from criminal cases. Others come from civil disputes, traffic incidents, or workplace investigations. Each case illustrates a slightly different aspect of how language interacts with the law. Because once you begin examining real legal stories, a fascinating pattern emerges. Over and over again, investigators, attorneys, and judges return to the same basic question. What exactly was said, not just what happened, not just who was involved, but what words were spoken in the moments surrounding the event. Those words can reveal intentions, clarify misunderstandings, or sometimes create entirely new questions. And when those questions reach a courtroom, they can influence how the entire case unfolds. So as you listen to the rest of this documentary, keep one idea in mind: language is powerful, not just in literature or politics, but inside the legal system itself. The words people choose in critical moments can echo far beyond the moment they were spoken. And sometimes those echoes become part of a legal record that lasts for years. Before we continue, I'm curious about your perspective. Do you think most people fully understand how their words might be interpreted in a legal situation? Or do you think many people underestimate the impact of what they say during stressful encounters? If you've ever experienced a moment where a simple statement changed the direction of a situation, feel free to share your thoughts. Because the intersection between language and law is one of the most fascinating and often misunderstood parts of the justice system. And as we explore more examples, you may start noticing something surprising. The legal system doesn't just evaluate actions, it listens very carefully to the words that surround those actions. Sometimes those words explain everything. And sometimes they create the very problem a person was trying to avoid.